Honor, looks like we're on the record. Your next case is John Moore versus Derrick McCall. That's A18772-979-C.
Okay, counsel, give your appearance for the record.
Catherine Ramsey, Laura Ungaro for John Moore, who's present on behalf of Mueller and Associates.
Okay, Catherine Ramsey, all right. For the record, now we have Ryan Hamilton appearing on behalf of the defendants, and he is in the courtroom. All right. This was a hearing that originally was extensively argued on September 15th, 2020 on the motions. There was a late minute filing, which is the reason I continued the counter motion. My understanding, I continued the counter motion by plaintiffs for reconsideration of the court's previous order that was filed on May 4th, 2020. And then plaintiffs also did a motion to amend the complaint. On the new pleadings, my understanding and I'll go through it when we do it again. So okay. I also said to you that I would give you a trial date, and it's my understanding, my staff got it set. You will have a bench trial on December 7th, 2020. Am I correct, counsel?
You're correct, Your Honor.
Okay, and counsel, I'm correct on that. Okay, so that was my first priority to make sure that got set. Okay. The first then is plaintiff's counter motion for reconsideration. Do you want to add anything? I know it was extensively argued, as you know, I was aware, but is there anything else you want to add to that, counsel, for plaintiffs?
No, Your Honor, I just want to make you aware there was another late minute filing yesterday by Ryan Hamilton. I'm not sure if you got that, their opposition to our motion.
I did.
It was filed
It was given to me this morning.
Okay. The only thing that I just want to add about that is that the consideration was that his likeness and his personality and him was being used to front this whole entire alleged reality show and the goodwill they received from that. But I also noticed that they kept in the Nevada civil RICO codes and did a whole section on that.
My understanding, you dropped that, correct?
Right. So I was just going to bring that up. I didn't reply or anything because I think they just didn't realize that they left it in there.
Okay, I did get a chance to read it, and between my different hearings this morning, I'll be honest, I did read it, and that was the first thing I started to say. My understanding is you dropped RICO, so I did read that. There was nothing different in the argument from, basically it was a little bit, as you know, I'm very aware of this case, so here's, do you want to add anything?
Yeah.
What, on the motion for reconsideration, I'm back to first of all, it would not be timely, except, unfortunately, there was never a notice of entry of order. Do you know that in this case, for that order?
Yes.
So, based on the case law I looked up, although it would not have been timely, because there was no notice of entry of the findings of fact and conclusions of law, I could review it as a motion to reconsider. Here's where I'm at, and I'll be honest, I read through everything again. The only thing that I would grant in that is a breach of contract for furnishings only. When we argued it, I looked through my notes, and I did carve out for furnishings. It was not explicitly done in the first findings of fact of conclusions of law. So since I'm not even reconsidering it, I'm really clarifying it because if there's no notice of entry of order, it was never done. So what I feel I will do then, here's what I guess I'm granting it as a motion to reconsider. I'm not even sure but what I will do is I will not strike all oral contract, but I will allow only an oral contract for furnishings only, but no good faith, bad faith, fear, nothing other than an oral contract, if you can prove it up at the bench trial, for the furnishings only, based on the facts that honestly I discussed quite extensively. I went through all my notes in counsel. I had a pretty long hearing, so I think hopefully you'll remember I did explain to the best of this judge's ability the facts. So I am going to grant it only for an oral contract for furnishings only, period. Okay.
Okay.
The next is
Thank
the
you.
motion to amend. It's no longer RICO, which, okay. If do you want to add anything, I went back through pleadings again. So is there anything else you want to add to the argument that you have briefed on basically the civil conspiracy?
No, Your Honor, nothing more to add.
Okay.
Judge, if I may.
Yes, Mr.
so-
Hamilton.
As we pointed out in our papers, Your Honor, and we appreciate that, the plaintiffs had filed on the 22nd. We were
Right.
able to get ours on the 28th. Judge, before a district court can even consider the merits on a motion to amend, when it's done untimely,
Right.
as it is here, the movant first must show some good cause. And
Correct.
they have not shown any good cause for missing that deadline, and it's a year that they've missed it. So we would expect to see some good cause, Your Honor, or, before we can even reach the merits, and here, no good cause has been identified. If the court does find that there's some good cause, even though it has not been identified yet, they still, on all the new causes of action that they're trying to either re-plead.
Really the civil conspiracy, and they tried to do the contract, but I've limited the contract, as you know now.
We understand, Your Honor.
And I'm not allowing good faith and fair dealing, bad faith and fair dealing, good faith
Sure.
and fair dealing. Sorry, I did the reverse, right? I had to look,
It's a lack of good faith.
it's a lack of good
Yeah.
faith. Okay. Jeez. I looked at the complaint this morning again, okay?
And so, Judge, if the court even could reach the merits on these claims, they still don't, it would be futile to allow these amendments, because for civil conspiracy, as the court is well aware, they have to identify some unlawful object that they acted in concert to try to achieve. Your Honor, my clients have had no object other than to try to benefit a veteran here, and in fact, they have benefited a veteran by giving him a place to live rent-free for a number of
For a
years.
dollar.
A dollar, Your Honor, and
A dollar.
we understand that. And so, Your Honor, there's no unlawful object. If this was an unlawful object, there would be charities all around town who could be hit with the same sort of civil liability for doing nothing but trying to help other people. Your Honor, there was some confusion as to what claims they were trying to amend, because there were a number of claims in the actual second amended complaint. And so I would reserve argument, Your Honor, if they're trying to add in more than the civil conspiracy. So,
Well, my understanding, am I correct? You tell me, what are you trying to add? Is it merely civil conspiracy?
I had to put you on unmute.
No, that's fine.
We're keeping everything in there that was in there with the new addition of the breach of the oral contract for the furnishings only. We've taken out the RICO, but we're asking for the civil conspiracy to stay in.
Okay.
Unlike what Mr. Hamilton just argued, they actually stole his image. They're using that. They benefited, Mr. Hamilton claimed that benefited veteran for years of having a rent-free home. Well, that wasn't the contract. The deal that they gave him was, this is your home. This is it. So, even his own representations to the court aren't accurate. That was not the agreement when they gave him that home. That was clearly on videotape. He also jumped on the bandwagon that if this case were to happen, that charities helping others in the community would then go, somehow be hit with this lawsuit all the time for this. Well, other charities in the community didn't do the acts of what Mr. Hamilton's clients did. There's no other charities out there stealing goodwill of the community by showing a veteran in need and exploiting his condition or his not so favorable position in life and upbringing him and then cutting the wheels out from underneath him. They don't do that. They actually help veterans on a positive note. They don't take the negative out after that. So I just want to let the court know that on the representations that he did benefit. He also actually got his image taken from him, and they were still using it, and they still are using it to this day.
Okay. All right, on the motion to amend, I'm going to deny it on two bases. Number one, it is untimely, and now we have a bench trial set for December 7th, 2020. And in addition, as you know, I extensively read it, and I do not feel the evidence shows that the plaintiff has not, I feel the plaintiff has not shown an intent to accomplish an unlawful objective, although they put the word scam in it, I don't find the intent there. So even though I'm ruling it's untimely, especially now we have a bench trial to get both of your clients, hopefully some resolution in this case, I'm denying as being untimely, but even if I had gone through, there's no good cause shown for the untimeliness. I don't feel there's an intent to accomplish an unlawful objective, so I'm denying it. All right, thank you, counsel. I appreciate it, and I look forward to the bench trial
Thank you,
with your clients so we can hopefully everybody get a resolution. Thank you, counsel.